Test. 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 Testing.
Talk with.
Yep.
So they can talk when it's like that.
When it's green, they can talk.
Okay.
When it's red, it's muted.
Not helping.
You're not eligible.
Hi.
Great, thanks.
Hello.
Can I interject?
Yes, you can.
This is Nicole Johnston from Aurora. I'm actually on my way to the meeting, but I had to drop off my kindergartner, so I'm going to be 10 minutes late to the meeting, and I just
have extras of those. Yeah.
Yeah, but they may have penguins.
I think I'm okay with that.
See, like why does it like
You don't want the front row again?
This time we took Washington, started out in Portugal Bay, we just got here.
All the way in this morning, all the radio kept talking about was how bad traffic was today. There's 2 seats. You could go sit right in front of those nice people from Boulder.
Somebody had
Oh, they got it covered?
stuff on the seat.
I would just throw that stuff off the seat.
am I gonna have to kick you?
You're gonna have to keep an eye on me. Again,
Oh man. I know.
I was actually surprised yesterday
I
that.
was restrained yesterday.
Oh, you
I
were?
wore harder boots today.
Oh, Jesus.
Yeah.
I left.
All right, I think we're ready to go here.
Test, test.
John is running numbers, so he's running all lane.
Hey, we need to start with Stakeholder 1 slideshow. We didn't finish. Okay. Well, you do that while I start talking. Good morning. Welcome back, all of you who were here yesterday. Thank you for coming back. And welcome to those of you who couldn't make it yesterday and are here today. Appreciate you being here. I was thinking about this a little bit last night, and a lot of people in the room, including myself, get paid to be here. I know there are a lot of people here today that don't get paid, so thank you extra special for giving up whatever other part of your day this might have entailed and for being here. We appreciate it. As I did yesterday, I just want to introduce a couple of folks. We have one of the COGC, one of 9 COGCC Commission members is with us this morning. Mr. Bill Hawkins is here at the table. Thank you, Commissioner, for being here. We have 2 members of the Governor's Task Force. As I can tell, if I've missed someone, please shout out at me. But Bernie Butcher is here in the front row, and Matt Sura is near the back there. I think those are the only 2 task force members that I see yet today. Maybe others will arrive later. I want to start out by saying hello to everybody on the telephone. If you're on the telephone, I'm going to ask you please to put your phone on mute so that. Wow, what timing! Probably not going to answer that one. Please put your phones on mute so that doesn't happen to you. And please do not put us on hold because the elevator music drives me insane. I want to recap a couple of deadlines just so everybody has them well in mind. Everything I'm about to tell you is posted on the COGCC website. You can Google COGCC or you can go to cogcc.state.co.us. Scroll down a little bit on the page. There's a link for the Governor's Task Force rulemaking. So the first upcoming deadline is this coming Monday, which is the deadline for party status. There's a form. Do we have hard copies in the back still? Hard copies in the back, or you can get that form from the website. It's a simple 1-page form. Pretty much what it gives us is your contact information. So we know how to get a hold of you for purposes of being a party to the hearing. After that, the next deadline is the pre-hearing statements that all parties have the right but not the obligation to file. That deadline is Wednesday, October 28th. Everybody who is a party can file a response to anybody else's pre-hearing statement. The response deadline is Friday, November 6th. We anticipate that the staff will prepare some revisions to our first set of draft rules, and we anticipate that we will do that not later than Thursday, October 22nd. Notice that I didn't make any promises there, but that's the plan. I want to reiterate the ground rules from yesterday. There's no winning here. Nobody gets points. There's no competition. We're all together in this trying to create the best set of rules that we can. As we talked yesterday after the meeting amongst ourselves here, here's our wish list. It's not very long. We wish that all of you would talk to each other a little bit more. Okay? We wish that industry was talking to the operators and, the industry would talk to the operators. Industry, you probably don't need to do that anymore than you already do. Talk to the local governments. Talk to the citizens. Let's get some dialogue going amongst you. We are in the middle. We're happy to be in the middle. That's our job to some extent. But I think there is an opportunity for some productive sidebar conversations, if you will. So anything that we can do to encourage that, we're going to try to do, and especially that might sort of be our format for tomorrow. We'll see how the rest of the day goes. But, you know, it is funny. I mentioned yesterday that we feel to some extent that this rulemaking is asking us to regulate behavior, which is an awkward position to be in. So help us out and reach across the aisle and talk to each other a little bit. So as an attorney by profession, one of the things that one learns when you're preparing a witness for a deposition or a trial is you say to them, please don't answer a question if you don't understand the question. Ask the questioner to clarify the question. Usually they ignore your advice. They usually ignore all the advice you give them. But I didn't follow that advice yesterday, I don't think, and I think I gave an answer that led to some confusion. And I think it probably arose from my own confusion about the question. So I want to clarify the following thing. When we're talking about the operator engaging with the local government permitting process, the permit approval from the local government, approval is not required before you can submit a Form 2A. What is required is that you go through the process to its conclusion. If that conclusion is a denial of the permit, then you've done the process. And armed with that denial, having gone through the process, you can come in and submit your Form 2A to the COGCC. That we would then evaluate the Form 2A, and there would be a hearing in front of the commission on your Form 2A. Apparently, it sounded to some of you as if I had said that you had to have the local government's permit approval. So not true. I hope that's clearer. Does anybody have any questions about that? Mr. Dempsey.
So, appreciate that.
Yeah, I'm sorry. So again, we're going to pass around to Mike, and please identify yourself before you ask your question.
Thank you, Director Lepore, for that clarification. I just, from a format standpoint, that slide that, as I understood it, I think it was slide 19, included new language in blue that would be added to the rule. Do you intend to have that language go into the next revision, or is that language to be modified? I'm just trying to understand what, kind of how to resolve that language with what you just said.
So Mr. Dempsey's question has to do with language that was on a slide. I could probably find that slide. It's actually slide 10. Got it. Okay. So for those of you that can see the screen, the blue language. The blue language was actually some language that was proposed by a stakeholder to us, by a local government stakeholder. I put it in there because I thought it was a clear, good statement. They thought that it helped the little I language that was our original language. So I would say to directly answer your question, Stan, we haven't made a decision to add it into the rule, to add it into the statement of basis and purpose, to not do anything with it. I think it's good language, and so that'd be a great thing for y'all to talk further about. But so that's the status of that blue language. Jamie,
Okay.
Jost.
Thank you. Just a quick question. So your statement was you have to go through the local land use process, whether to finish it up. And if they deny it, then you can come forward. What happens if the local government neither approves or denies the permit? What do you do then?
Okay, so I'm going to answer a limited number of hypotheticals, but I understand that at some point the operator, maybe the local government too, but the operator might say this is going nowhere. If you get to that point, come to us and say this is going nowhere. We'll probably pick up the phone and call the local government and say, the operator says it's going nowhere. What are you doing? It's going great. It's taking us a long time, but it's going great. We just have to make a judgment call at that point. Okay, so let's try to pick up where we left off yesterday. These don't have slide numbers. Getting warm. Okay. The next subject for today, to start today, is the language in our rule that proposes a role for an adjacent local government. And by adjacent, we mean a local jurisdiction, a local government that is outside of the boundaries of the jurisdiction in which the site is proposed. So to put it in plain English, let's say the site is proposed in Erie, close to the border with Weld County. In that case, Weld County would be the adjacent local jurisdiction. Our rule contemplates that the operator would notify adjacent local jurisdictions if they are within 1,000 feet of the proposed location. And with that notification, give that local government, the adjacent local government, an opportunity to comment, meet with the operator, meet with COGCC, talk to us fundamentally about best management practices at the location. We've tried to be in our rule very, 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 very clear that adjacent local government does not either have a right to approve or disapprove the location, the site, the physical place where the site is built, nor does it have a right to ask for a hearing on that location in front of the commission. So that right to ask for a hearing most often gets translated into shorthand as standing. So our proposal would not confer standing on the adjacent local government to ask for a hearing. I know there are questions I know there are a lot of questions about this. I think we've acknowledged by putting this language in that bracketed bold text that an argument could be made that this particular opportunity was not contemplated expressly by the task force recommendation. That said, in our meetings around the state with stakeholders, very few things came through as clearly as this need and this desire of local governments who might not be where the site is, but whose citizens might be affected to participate in the process. I would add that I think it's squarely within the spirit of Recommendation 17. And I know I can anticipate the comments. I know that the 21 members didn't vote on the spirit of the thing necessarily, but we're going to go down this path. The other point I want to make, and then I'll open it up for some comments and questions. We always we have already, as most of you know, the opportunity for the public to comment on our applications and permits, and we have the opportunity for local governments to comment on our applications and permits. And a lot of times people ask, well, what happens to my comments? Do you read them? You don't necessarily respond to them. So yes, we read them, and yes, we actually do respond to them. We put them in comments to the Form 2A. We don't respond, item by item specifically to a given commenter. We look at the comments in the aggregate and say, we considered the distance to the nearest surface stream, and this is what we did about it. In this rule, we have proposed that we, the COGCC, would respond directly to the comments of an adjacent local jurisdiction. Other proposals have come forward to us suggesting that the operator be the responding party. So I would invite some discussion on that point. We put that burden upon ourselves just so that there would an effort to ensure those adjacent local jurisdictions that there would be a substantive and fulsome response. The timing of that response gets a little tricky. I'll just throw that out there to tell you that it may be hard to respond to those comments until we actually have a Form 2A permit to look at, until we know exactly what the site location is going to be like. Okay, so I'm going to stop there on that point. I saw at least one hand in the air. There are a lot of people shifting seats and looking for space. We have 2 conference rooms in the building that have video of this table and of the slides. So if you want to have a seat and be a little bit more comfortable, I'll have one of my staff escort you over to one of those conference rooms. Greg, are you going to do that? No, you were getting a microphone out. Jen, would you mind? Does anybody, I mean, you're welcome to stand here. I don't mind. But if you want to go sit in a nice conference room, we can do that for you.
There are a few other seats around.
If you have an empty seat next to you, would you raise your hand, please? Okay. First hand I saw was yours.
Hi, I'm a citizen. My name is Maria. And with this rule, when you say that the adjacent local government can't ask for a hearing in front of the COGCC, the proposal specifically in my neighborhood is for
Can you talk into the microphone a little closer? Thank you.
Sorry. A large scale facility that is in a small pocket of unincorporated Adams County with the city of Thornton surrounding it completely, with 2 schools just barely outside of the 1,000-foot zone. And the city of Thornton would definitely be affected by this. If there were any right-of-ways for pipelines, they would need to negotiate with the city of Thornton. I would like to see something in here that says if the adjacent local government would be necessary for them to, I guess, negotiate right-of-ways or to measure school zones or outside, designated outside areas, things like that, that they would have the ability to bring that to a hearing here if they're impacted.
Thank you.
Tom Parco with Will County. As the county mentioned yesterday, we are opposed to have any non-jurisdictional entities, whether that be municipalities or counties, commenting on locations that are not within their jurisdiction. With that being said, when you go into 306B 4D little I, if this does stay intact as the language is proposed right now, we would ask that the COGCC also include the jurisdiction where that operation is taking place. So when you do meet with an operator and a entity that is outside of that particular jurisdiction, that we be included in that process as well. And then with respect to 306B 4D triple I, we would request that this language stay intact.
Thank you, Mr. Parco.
Matt Sura with Boulder County. I think that it would be really helpful for the Colorado Oil and Gas Conservation Commission to do a little bit of research and maybe analyze areas that are urban growth areas and to determine really how the development is occurring. If you look at the town of Windsor, city of Greeley, you can see that most of those areas, and certainly the most of the residential areas, are being drilled from outside those municipalities. And that's maybe as it should be. I thought it was, sorry. And that's maybe as it should be, but we also know that the transportation issues that are felt by those municipalities, certainly some of the residents are going to be impacted. It makes sense for there to be at least some sort of consultation. And what's being proposed, I think, is a start, although it should be much farther. It should be a mile. The other reason that it should be a mile is because we've got to have more flexibility. Part of this consultation is that it happens before there's a surface use agreement in place. Therefore, it is not a finalized location. Therefore, there's got to be some flexibility as to where it finally ends up. If that's the case, if there is that flexibility, then you would want to have those local governments that, you know, it could be closer to, it could be even within their jurisdiction. The problem is that if you get into this process and you find out that location really doesn't work, it needs to go to another location that is inside a new jurisdiction, then it's a whole new process probably. It would have to be completely renoticed. Keeping them involved at the very beginning would make for a more streamlined process.
Thank you. Oh, Kirby Wynn. Kirby. Kirby, are you there? Apparently not. All right, who's next?
If I have the mic, does that make me next? Okay.
Does to me.
Jackie Kowalski, a resident of Wadley Farms. I would just kind of concur with what the gentleman over there said, in that if the alternative site analysis,
Yeah, I don't. Yes, Kirby, we can hear you. Sorry, there seems to be a delay. Would you mind holding on while we've got Kirby? I promise you're next. Kirby, go ahead. This is Kirby Wynn from Garfield County.
Can I finish?
Appreciate that. So we just wanted to add some emphasis. Okay. Jackie called.
Time warp. Kirby, go ahead. Can you do anything about that?
This is Kirby Wynn from Garfield County. Yeah, my apologies. The time on the internet sound feed is different than from the phone, so I was a little confused there. Anyway, we just wanted to add some emphasis to what Weld County said about the local government with actual land use decision jurisdiction does need to be involved in all these discussions and the communications when the adjacent local government's being consulted.
Thank you, Kirby. Ms. Kowalski, your turn.
Okay, and I just briefly, if the alternative site analyses are to be meaningful, the surrounding jurisdictions need to be a part of the process as early as possible, and quite frequently those are with beyond 1,000 foot.
Thank you. Can we get a microphone to?
Oh.
Share the mic.
Do I get to say something?
Thank you. Kate Hall from Larimer County. I first thank you for having this. We definitely appreciate the opportunity for the input. I'd like to propose or suggest that at the end of 306B for Big D, it might be expanded to include all local governments with land use authority within the operator's proposed drilling and spacing unit. I feel that if there's an alternative site that may be available, the most likely place for that is within that spacing unit. And I feel that it won't add much. It would be nothing more than offering that notice, same as the 1,000 foot. But I think it would be a meaningful notice, and with the activity along borders between counties and municipalities. The ones that come to mind are the Pace site by Bethke Elementary, Wadley Farms. Some of the most contentious sites are due to minerals being extracted under one jurisdiction from just outside. And so I feel engaging them earlier could be a great benefit and also could probably speed up the process for operators. So thank you.
Thank you. Stan Dempsey.
Thank you, Director Lepore, Stan Dempsey, CPA. I think one of the concerns we have is on the adjoining issue, who do you listen to? Do you listen to the local government that has jurisdiction? Or do you listen to the other local governments that may have wildly different opinions on the process or the results? I think we have some of the similar questions about really what standing is and what standing isn't. And I think this will increase the permitting time and really works against the timely and efficient permitting process that's in the statute. Thank you.
Thank you. The short answer is I listen to everyone.
Sorry. Good morning. My name is Dr. Chow. I live in Hunters Glen, Thornton, which is close to the Wadley Farm, and I am concerned about this 1,000 feet. Remember in August 12th, Tianjin explosion, August 12th, 165 people died and 8 missing, caused by 700 tons of sodium cyanide. And in China, they do have rules. All the industrial facility must be outside 1 kilometer outside. In other words, within the 0.6 miles, no homes around that industrial facility. And right now, we are facing a fact is that where I live, I'm within 0.5 miles. No, it's right, 0.5 miles of this synergy proposed site. Okay. And so what I'm trying to say is that we need a standard better than China. Okay. Because we are American, we are first industrial country, right? China only second right now, right? And so my point is this. They proposed a 20 wells, gas and oil well site. That site is a 20, okay? Think about this is oil and the gas, which is quite dangerous and especially pressurized things, which is a very dangerous time bomb.
Thank you very much for your comments. Are there any other questions on this particular provision of the statute, of the proposed rules? I see Ms. Jost in the front and somebody's hand in the back, and I will get to the back row here shortly.
I think she asked first.
Yeah.
Thank you, Jamie Jost. One general comment, just to follow up on the comment to the definition of large UMA facility, is in your proposed section D, it references the land use authority within 1,000 feet of the proposed oil and gas location. Again, we'd request that that be a multi-well pad, because if you use the term oil and gas location, you're definitely expanding outside the scope of that recommendation. As a whole, I think this does, as you mentioned, does go outside the scope of the recommendation. So that's just an overarching comment from the COGA perspective. But with respect to the suggestion that this be expanded potentially to a drilling and spacing unit, I think that could absolutely lead to a lot of uncertainty, delay, and controversy between these adjacent local governments and the local government with actual control over the site. Drilling and spacing units can be 320 acres, 640, 1280, 1920, whatever the case may be. You completely go outside the scope of even 1,000 foot at that point in time. And really from the standpoint of allowing an adjacent local government to provide comments, I think initially when you open this, there was a comment of, does the director respond to those comments or does the operator? If the meeting is to be with the director and the operator, I mean, the COGCC should provide a response, but that should be at least in correlation or after conversation with the operator, because it's the operator's permit that is being reviewed and going in with respect to any comment, not just comments from an adjacent local government. Overall, I think at this point in time, I mean, there is a problem with this because it is outside the scope of the recommendation, but those are just some considerations as you move forward. Thank you.
Thank you. A couple of hands in the back, and then we're going to keep going here.
Hello, good morning. I'm Amanda Harper, and I wanted to concur with a few of the things that have been said and then bring up a couple other points. I really think that 1 mile is minimum for notification for adjacent local governments and citizens around a large-scale facility because of traffic affecting all the people in the area around a large facility, and also visual blight that will involve all the people around that area. And then another piece is from the permanent structures that are going to be there, especially with the facility site. And then there's also very many emissions that have been proven to be coming out of these sites, and on a regular basis. There's floor camera footage of them all over the YouTube, and those don't know boundaries. They go wafting into adjacent counties and municipalities. And I think that needs to be taken into consideration, the emissions. And then the adjacent government should be notified as soon as the local government, if any of the county that it's going to go into. And then I also think that we need to slow down the permitting process. I know there was a process a few years ago that wanted, the industry was here fighting to have it go faster, and I think we need to slow it back down a little bit with these these huge sites. It needs to be slowed down. We need to give local governments and citizens time to relate to all the different issues, and it takes a lot of time.
Thank you very much for your comments. There was one more in back, and then Mr. Neslin in the front, and then we're going to move on.
Nilsa Mahon from Wadley Farms, and want to thank you for the opportunity to giving us to provide our feedback. I just want to mention that yesterday, Director Laporte, you mentioned that the mineral rights for the operator, that's their assets. I wanted to ask you today and everyone here just to think about the homeowners. The only assets on the homeowner's balance sheet is their home. So the proximity and from our neighborhood and everybody that live on Hunter's Glens, you know, that will definitely be affecting the property value, and that's what we need to protect also. Thank you.
Thank you. I'm going to ask again today that we try to stay focused on the provisions of the rules that we're trying to address. I know there's a lot of overlap, and there's concerns and all of that, but in order for us to get through this process in the next couple of days, I just appreciate if you could kind of stay focused on the topics at hand.
Director Laporte, in recommendation 17, there's language talking about the consultation process for the local government with land use authority, and then there's following language saying other local governments may continue to use the current local government designee comment, permit, condition, and hearing process, which I would read to suggest that the task force was saying for other adjacent local governments, they'll rely upon their existing rights under your Form 2A location assessment, comment, input, consultation process. Am I misreading that, or do you think that the task force just got that issue wrong?
Dave, I'm going to defer an attempt to respond to that. I haven't given it that much thought. The language you read from the task force, I recognize that language. I haven't thought about it in the context of the question you just asked, and I will do that. Okay, so I've put up on the screen the last couple of subparts of the proposed language. I think we've had an opportunity to really kind of to address all of that. So I'm gonna move on. In fact, I think that wraps up where we wanted to get to yesterday. And I'll take just a second to move over to the next slide deck, and we can start on the next part. Well, I know there's a delay. I don't know how to quite deal with the delay on the webcast feed, but while we move over to the next slides, does anybody on the phone want to ask a question or make a comment about what we've covered so far this morning? Julie, are you moving me over? So I need the next slide set. Thank you. Okay, we are going to forge ahead. Can you turn this up a little bit? The next major subject under the staff's proposed rules relates to best management practices and mitigation measures for a proposed large urban mitigation area facility. We have taken, I think, a somewhat different approach to this than we have in the past in a couple of different ways. First, we've separated out 3 separate categories of best management practices, required mitigation measures, and sort of potential mitigation measures. Second, we have included within this section a proposal to put a time limit on the duration of the drilling and completion operations at a large urban mitigation area facility. So I know that those are some things that will certainly raise questions and conversation. This goes to the third part of recommendation 17, which is circled there. It says, the third part of the recommendation is to address the authority of and procedures to be used by the director of the COGCC to regulate the location when permitting large-scale oil and gas facilities for the purpose of reducing impacts to and conflicts with communities. This shall include siting tools to locate facilities away from residential areas when feasible. Where siting solutions are not possible, the director would require mitigations to limit the intensity and scale of the operations, as well as other mitigations to lessen the impacts on neighboring communities. So we talked a little bit yesterday about our 604 C2EI rule about alternative locations. That analysis would apply to all of these locations that are proposed in a buffer zone. We will continue to do that. We talked yesterday about the decision not to expand the definition of urban mitigation area in this rulemaking. That constrains us in some ways to a 1,000-foot radius around a proposed large urban mitigation area facility. With those two things in mind, we started with some introductory language in 604C4, and you can read it on the screen. I'll read some of it. Large UMA facilities should be built and operated using the best available technology in conformance with state of the science measures to avoid or minimize adverse impacts to adjoining land uses. So I'm going to pause there, excuse me, and explain our intent. Our intent is that if an operator is going to put a large facility within 1,000 feet of homes, it needs to be operated in the best possible way that it can. And that changes over time. Technologies evolve rapidly in some cases. The state of the science evolves. So this language is our effort to indicate that the expectation is you're doing it the best way it can be done. And that because we can't dictate or prescribe today what that might look like tomorrow, we're putting in sort of this overarching standard statement. And the expectation then is as things evolve, such as vapor recovery systems, to give an example, we would expect as vapor recovery systems come into the market, if you're going to put a large urban mitigation area facility in, you'll have a darn good vapor recovery system. Okay, so that's our intent. I will say throughout this section, more than other sections where we are dealing with these technical matters, staff may not always get the language exactly right. We understand that. We want the conversation about exactly, we know what we mean. What we said may not line up 100% with what we mean, and we'll have that conversation about how to make what we mean and what's in the rule line up. But the intent here is that this is a moving target. We can't write it down prescriptively. Okay, I see your hand. I'll call on you when I'm done. So
Back one or two.
I think they're running a little online gambling thing. So I'll keep going. To achieve the objective stated above, the Commission will require a combination of best management practices, required mitigation measures, and site-specific mitigation measures related to operational and technical aspects of proposed large urban mitigation area facilities. So I want to break those three down. Required best management practices, we've listed some subjects, and as to those subjects, we would require kind of the best available technology to be applied to address each of those areas. We understand, and members of the audience need to understand, that too will depend on a given site. It will depend on the configuration, the size, the proximity to homes. There will be a lot of factors that will go into play, even as to addressing, I'll take what I think is a relatively easy one, a fire hazard. If your location is admittedly in an urban mitigation area, but 3 miles from the nearest fire station, that's a different circumstance than if the nearest fire station is on the closest corner to your location. So we have to kind of look at those circumstances and figuring out what the right solution is. The point is we need a dang good solution to that fire hazard for these locations. Okay, so that's the required best management practices. The required mitigation measures are twofold. We already have a long list of mitigation measures required under 604C for any location within 500 feet of a building unit. We just imported that into this part of the rule as well. So everything that's in 604C 2, A and B is part of this, okay? But the B part is within 500 feet. There's the exception zone. So it's everything. The second part of this required mitigation measures is the duration on drilling and completion operations, and we'll deal with that in a second. But that was part 2 of that, is proposed to be a requirement for all large urban mitigation area facilities, that there's some hard deadline on how long the operator will be conducting the 24/7 drilling and completion operations. And again, we'll talk about how there's probably some circumstances that would come into play that might alter or mitigate that hard deadline. And then finally, on a site-specific basis, we would address conditions that might or might not be present. And we can anticipate those. And we'll talk about those. Again, we've dealt with those in the rule on sort of a topic-by-topic basis. And then the final language in green there is, again, sort of the savings clause that local governments indicated was important to them. Sometimes there's a concern that when we articulate a best management practice, and somebody earlier in the audience mentioned sort of the visual impacts. So we can have visual impact mitigation measures, but sometimes then local governments feel that we're intruding on their jurisdiction to regulate visual impacts. We aren't interested in intruding on local government jurisdiction. So that's why this savings clause is there, so that we can try to avoid the circumstance that the operator says, well, COGCC told us to paint the tanks green, and you're telling us to paint them brown. And you can't tell us to paint them brown, or we have to paint them green, or whatever. That's a silly example, but that's the idea. If local governments want to regulate this stuff and it's in their jurisdiction to do so, we're not trying to impinge on that authority. Okay, with that, all right, are there specific questions on this part?
Yes, I have a question. If you can go back one slide to the part that talks about the directors, or the one, the circle, the red circle page, right there. It says to address the authority and the procedures used by the director to regulate them. So my question is, when I look at the language of this, I don't see anything that says you will, with your authority, permit or deny permits. Everything says that you'll permit. And if we have a situation, for example, Wadley Farms, where there could be upwards of 4,000 children with 2 school campuses just outside the 1,000-foot zone, can you envision a situation where you might not permit a UMA? Or is it always going to be permit a UMA but put provisions in?
Yes, I can envision such a circumstance. When I elect to deny a permit, the operator by statute has a right to go in front of the full commission. So just there's no secret here. The vast majority of applications for locations and permits are approved at the staff level, so administratively, without going to the commission for a hearing. I can deny a permit, and if I do, it goes to the commission for a hearing.
Okay, and if you do permit, I guess, and we do have a situation where we could have an explosion or something with oil and gas that close to children, I guess our dang good provisions would be what we would expect to protect them? Yes.
So just so we're clear, the 500-foot and 1,000-foot setbacks that we have were modified. They've been in place for a very long time. They were modified in 2013 in a process very much like this one. And we're very comfortable with those. Those are protective of public health, safety, and.
But it doesn't seem like anybody else in the state is comfortable with those that have these large facilities beside them, except for people who are operators or in this industry.
Thank you. That's your opinion, and I appreciate it.
Okay.
In the back.
Hi, my name's Jerry Nelson. I'm Watley Farms resident. I'm just south border of the proposed field. If I can just get you to 1, explosion chemical toxic emissions. Am I supposed to sleep better with my daughter's bedroom 550 feet away from this site because you're going to use best management practices? That just isn't going to make me sleep any better. And That would even be better than your suggestion yesterday of building townhouses there or apartment buildings. Because this is a highly explosive situation that's going to be 550 feet away from my daughter's bedroom window. Best management practices doesn't seem to address much of anything.
Thank you.
Thanks, Dan Kramer, City of Longmont. Just want to clarify a little bit on that savings clause. And maybe you already said this, I just want to be sure. You mentioned visual impacts. In Part C, just above visual impacts, is a provision on ground and surface water protection. So am I understanding you to say that what this savings clause does is, if the COGCC is asking for certain groundwater protections and the local government within its authority has regulations on groundwater protection or groundwater monitoring already, and the local government applies those, then the COGCC's action is not intended to preempt what the local government is doing.
Why do I feel like I need my lawyer every time you ask me a question? So Dan, I'm not going to try to, anticipate preemption arguments. There are a lot of gray areas in the preemption law, as you well know, about whether and what parts, and groundwater is one of those, I would assert that the local government has a right to regulate. I can't answer those kinds of questions in this setting. I promise you we'll have groundwater monitoring rules. You know that we already do. If you want to have a court sort out what Longmont's rights are vis-a-vis the states on those groundwater monitoring rules, then that's a question for a different day.
Fair enough. My question wasn't meant to be specific to groundwater monitoring, so let me ask it about visual since you brought that one up. What I'm understanding you to say is, if for some reason the COGCC imposes some sort of visual mitigation, and the local government does too, maybe they're different, maybe they're not even in direct conflict. What I'm hearing you to say is, what the COGCC is doing is not intended to preempt what the local government is doing. Is that correct?
I think that's a fair statement, that where there is clearly some joint or dual or overlapping jurisdiction, and we say, again, maybe we say use a berm for visual mitigation, and the local government says we'd like trees. And if the local government has that jurisdiction and that authority, then I guess they're using berms and trees.
Thanks.
Or we'll try to work it out. Yeah, Greg's Duranlo, my environmental manager, is making a very good point, and that is that hopefully the local government and the operator are working this out, and when it comes to us, that's part of the permit. That's part of their application, is here's our visual mitigation measures as approved by the local government, and then we're all good to go. Gosh, I was hoping that would take your question away, Miss Aldridge.
Mine is just a clarification on the next slide.
All right, well, let's see if we're ready to go to the next slide. No, we're not.
Sarah Barwinski, Well, Deer and Water. Part of this really does move into mitigations, but obviously the siting tools was the preferred method. And I'm assuming that part of what you do when you try to locate something as far away as possible is part of that potential of changing the siting on it. And I wondered if there was anything that you've learned, or perhaps that we've learned together, that could explicitly be put in rule, because you've said on several occasions, and I sympathize, that as far away as possible is hard to implement. And I think that we've done a good job in trying to do that through collaboration, through things like moving things out of residential areas into areas zoned industrial was one method. One method was dividing the intensity so that it could be located further away. Another was the operators buying property that was more appropriate. And I think a very creative one was pad sharing and working out things. So in that sense, there's a message of hope here in the Greeley experience that we've been able to move some of the most problematic using siting tools. I'm concerned, though, in a lot of communities, if Matt Lepore is no longer the director, or they don't have an active citizenry that would be willing to engage, that those siting tools get lost. You know, if it's as far away as Mars or Beijing, maybe it doesn't happen. So are there things, or would you entertain language that would identify potential siting tools? Some of it your staff utilizes. I think that would feel better for people to not think that we're just talking about mitigations after the fact, but they really are some teeth in trying to make more appropriate locations.
Thank you. I would ask that you submit any such language for our consideration. Ms. Jost. Need a mic? Who's got the mic?
I do. I'll.
Chandra Berry.
Yes, Chandra Berry, Fort Collins, Windsor citizen. And first, I'd just like to thank the COGCC for the help that you offered in the Windsor area. And I'd like to echo what you said about everyone working together. In Windsor, the industry, thank you. The local government, thank you. But really, I'd like to give a shout out to the citizens. The citizens changed hearts and they changed minds. And they're very grateful. Now, to echo Sarah, at the risk of jinxing your longevity, Director Lepore here, and you escape us, I would propose that for the duration of drilling and completion, that we make it a 90-day period, and that would not then have a moving target for the industry or for the local government or the citizens.
Thank you. We'll talk a little bit more about duration in a second. Jamie Jost.
Great. Thank you very much. I have, just fair warning, I have several questions, but hopefully they don't take too long. The first one is by the use of the term in 604C in the first paragraph that you did have up. I think it is the next slide, the one that Ms. Aldridge was referring to. You use the language of best available technology and state of the science. So two questions with this is one, I mean, who does the COGCC believe determines that? Because that should lie within the realm of the operator. And how do you correlate that with your Rule 305 that already requires language for technically feasible and economically practicable? Because this obviously seems to be a heightened standard for large UMA facilities, but you already have rules that apply to these. So on that, it's just kind of a question of the use of those terms, state of the science specifically, because that's a known term. Best available technologies is a little bit different, but who does the COGCC staff determine to make that decision as to what's best available in state of the science?
So I think ultimately that decision rests with the COGCC. If best available technology and state of the science are redundant, I'm happy to kind of think about that and look at that. This, in my mind, and it's my language, so I'll own it, was a qualitative statement more than a quantitative statement. We will not abandon the economically practicable and technologically feasible, or maybe it's vice versa. I can never remember.
You got it right.
Those four words, you know, are applicable here. So we're not likely to attempt to demand that an operator invest in a technology that's unproven, still extraordinarily expensive because it's not really been commercialized. But we're also not going to be very sympathetic to the argument that, golly gee whiz, that's really expensive and we'd rather just do this. So that's kind of the balance that we're trying to strike. And if there's better language again, or if we don't intend to be redundant, we want to signal an expectation.
Thank you. And another question. I think I at least warned everyone I have at least a couple, if that's all right.
Okay.
The next one is when you were drafting these rules, did you take into account the Colorado Oil and Gas Conservation Act that actually requires the cost effectiveness of mitigation? I mean, I'm assuming there's probably going to be a cost benefit analysis done on this, but it's a requirement of the act that mitigation be cost efficient. And when you have the BAT and the state of the science language in there, again, to your point, it has to be taken into account. Have you thought about that as you were drafting the rules?
You mean there's a statute I have to follow?
There's a statute out there.
Yes, we're cognizant of it.
Thank you. And the last question is just with respect to a local government and an operator's agreement. So at this point in time, there could be an agreement in place between the operator and the local government. If that agreement had mitigation measures in there that were different than what is in this proposed rule, how would the COGCC deal with that?
So the agreement, here's off the cuff, and I reserve the right to change my mind, but that MOU gets you past this entire consultation process, right? It doesn't get you past our Form 2A evaluation. And so our Form 2A evaluation is going to proceed certainly in light of that MOU, knowing that the local government is satisfied with what's in the MOU is huge to us, but it might not be definitive or the end of the discussion. Oh my goodness! The woman in the back in the blue sweater has had her hand up for a very long time. Let's go there. I'm going to ask. I know a lot of people in the Wadley Farm section. I think we had a box reserved for you guys. If what you want to say has already been said, would you just please consider that for the time aspect of this? And there's quite a few other questions or comments in the front part.
Well, bad news. I am from Wadley Farms. My name's Pamela Bond Simmons, and I'm concerned about the idea of cost effectiveness for the energy company that's going in, and what technological things would be happening to protect us. Because I'm concerned with the amount, I believe that best management things are in place right now. However, with the number of fires and explosions, emissions that have occurred, it makes me concerned about what people and our leaders are thinking about what best management things are. And so therefore, I'm asking, I think that this should be clear as to what best management things are, so that the residents that will be directly affected can see. And also in terms of cost effectiveness, that also should be a point that is brought up, that just because it's cheaper and perhaps that the technology has not been proven, but has been somewhat proven, that they don't have to agree. So I feel it's very important for you to take an important role in this, in protecting the citizens that rely on our government. Thank you.
Thank you very much for your comments. I want to point out that, again, part of this entire process is designed to allow you to have that input both through your government, through your local government, in the first place. That to me, that's sort of in this process envisioned as the first step. And then when it comes to the COGCC for our Form 2A, we again have a public comment period. So that's another opportunity for you to engage and make the kinds of, in a more specific, site-specific basis, those kinds of comments. And we've proposed to extend that comment period from 20 days to 40 days for these kinds of facilities. I'm going to take this gentleman here, and then there's a bunch in the front row that we need to get to. Yes.
My concern is still about this 1,000 feet.
Okay, sir,
okay.
I understand your concern about the 1,000
yes,
feet. Do you have another
but,
comment or question?
No.
Do you have, okay,
no,
so
no,
let's
no,
give somebody else the microphone.
The question is, you didn't address how the danger of the natural disaster, lightning, or the tornado, or the hail happened to the facility, caused the explosion. Okay, So my question to you, you still say 1,000 feet is enough. What I'm saying, within half mile of the site, people's life is in danger. They are not under the, it's up to your rule. Okay. If you don't have the rule up a half mile, only have this 1,000 feet. God forbid, lightning strike, tornado, touchdown, something else, the terrorists find this as a good explosive site, or the disgruntled employees sabotage the site. How do you address those people's life? They will be dead. I want you to address this, that 1,000 feet. I say, that's not enough. Would you please address my concern? You have no control of the God, okay? You have no control of the weather. You have no control of the terrorists. All these other things, not important. You can manage everything. That's human. You have no control over the God. Please respond. God will.
So I clearly cannot control many things. I will say that there are 53,000 wells operating in the state of Colorado. We have a 150-year history of oil and gas production and development in the state. We have been through a flood in 2013 of an extraordinary proportions. So far, the record for citizens adjacent to these locations is unmarred. Okay, next question, Mr. Busher.
There. The recommendation labeled third included language, this shall include siting tools to locate facilities, etc. I must tell you, I really like what you're doing with best practices here. I'm a little unclear as to how this interfaces with your ability to urge a different site. So specifically, the question would be, in this process, will you have the authority to say, if you do this site, we are going to require this level of best practices and mitigation. If you do a different site over here and propose a different site, we will require something less. Do you feel you have that flexibility and that authority?
Bernie, the short answer is yes, but I just want to phrase it slightly differently. We fundamentally look at every single site on a one-by-one individual basis. And especially that's true with respect to the best management practices, the mitigation measures. We typically talk about conditions of approval. So every site, that's what our oil and gas location team led by John Noto, that's what they do, is they look at this and they look at everything. And you're mostly, in this conversation, mostly points to the proximity of residents and people and schools and all of those things. All of those are evaluated. Here, again, by definition, we're talking about facilities that, number one, are going to be large, and number two, are going to be within 1,000 feet of 22 building units, or at least 11 building units on one side. And so we're automatically talking about a situation that is getting heightened scrutiny. And what we've tried to do in the rule is say that it will be subjected to the highest scrutiny and the highest expectations and the highest standards. Now, if you move it outside of that, and I think maybe Sarah alluded to this or someone else, if you move it 1,001 feet away, do those expectations change dramatically? Well, they don't. And we have some savings language in here to make ourselves more comfortable that just because you're not in the urban mitigation area doesn't mean we might not also ask you to use the best vapor recovery system that's available in the marketplace. So I hope that answers your question. Your fundamental concept absolutely lines up with where I think we are. Ken Wanstolen.
Matt, I'm concerned that the last sentence of this section is incompatible with the operational conflict standard of the common law that you are advancing in litigation, and that you don't have the authority to change the common law. So I'm just making that observation.
Thank you. Okay, I'm gonna take two more on this point, and then we're gonna go keep going. So Dan Johnston. Yeah, hold on. There's somebody on the phone. Yes, Mark, I can hear you.
All right, I'm sorry. It can't tell from our end.
Yep, I understand. Do you want to make a comment or question?
I do have a comment on this element.
Okay, please go ahead, and we'll get to the next people in the room next.
Okay, so on BMPs, Erie is looking for more specificity in the language. I realize that you want to keep the door open for best technology as it comes forward, and we certainly agree with that. But in the interim, I think the language could address directional lighting to keep it away from residents' homes. And you could certainly address lowering the dBA level in this zone that we're dealing with, which is more sensitive to residences. And additionally, we could probably put language in that moves us away from or asks that the operators move away from fossil fueled site equipment, which will lower the sound level. So we're just looking for more specificity. It's pretty vague at this point.
Thanks, Mark. I will respond to that a little bit. So lights, for example, are already part of 604C2A, I believe is the right section, and that's been incorporated by reference. So downward lighting is required for these locations. It's required for any location, large, small, medium, within 1,000 feet of a building unit. Noise, again, more or less the same answer. We have a noise standard. We are, as you well know, working on new noise rules that will be forthcoming sometime early next year, I hope. The fossil fueled site equipment, I think, to me, gets into that realm of where I would probably not prescribe that in a rule, but that's exactly the analysis, right? Is what are you using? We're later today, some of us are going to a site that is being fracked using electric generation on site, fueled by site gas. It's pretty remarkable. We know that can't happen at every single site, but it's a question to ask. What are you going to use? And certainly the fossil fueled engines has downsides. So one there that I wouldn't probably prescribe, but that I promise we will consider as we evaluate these on an individual basis. Dan Johnston.
Okay, thank you.
Thank you, Mark.
Pushed it one too many times. I have a process question that is a follow-on to Ms. Joseph's question. When you talk about applying best available technology and state of science measures, one of the concerns of impacted communities is the variability across operator. Some operators have, much greater financial ability to incorporate technology than other operators do. When you are applying best available technology and state of the science, do you take into consideration under the economically feasible standard what an operator can do, or are you going to apply these universally across all operators?
I'm going to give you a broad brushstroke answer, okay?
Yeah.
And I think a little bit of this context, I hope this helps a little bit. A 1 mile horizontal lateral in the Niobrara Shale has about a $5 million sticker price, maybe 6, maybe more. a pretty significant capital investment. So our experience thus far is that, you know, the mom and pop operators that we have in Colorado are not the ones making applications for these sites. In that context, I don't see us accepting. I don't see us asking for pie in the sky technology. Okay, I've sort of addressed that. I also don't see us accepting, I can't afford that at this location for any technology that is commercially available, no matter who the operator is. If you can't afford what we're asking you to do, you shouldn't be asking us to build this site in this location. Okay, last, there's what, there was a woman, somebody over here on this side has had their hand up for a long time, and then we'll do Matt Sura, and then we're going to move on.
Okay. Matt Sura with Boulder County. We had a lot of debate in the task force about the unique nature of the drilling in oil and gas development, horizontal drilling and hydraulic fracturing that was leading to these super wells and super pads, because we're co-locating a number of very productive wells on a single pad, leading to what could be unprecedented amount of explosive potential, I guess, on a well pad. And those were being placed kind of surprisingly to all of us. The industry was using the 500-foot setback as an excuse to ask for those locations next to residential areas. And I think that we will all, at this point, recognize that a lot of those were probably irresponsible locations. Examples being Midtown Directional, the Gilbert, the Pace, South Greeley, which is the Frontier site, the Sheep Draw Directional. All those were moved based on conversations that both the local government, impacted communities, the Colorado Oil and Gas Conservation Commission were having with the operator. So we have the ability, we know that they have the ability to move these locations. When we were doing the task force, there was a real push to try to increase the setbacks for large scale facilities, and that failed. But what replaced that, Matt, was giving you new siting tools to move those locations as much as possible away from residential areas. And we really don't see that in this draft. What I guess I would like to propose is that as part of 306B4, the materials that are given to the local government that are being consulted, that is an alternative location analysis. Colorado Oil and Gas Conservation Commission staff has done an excellent job starting to incorporate alternative location analysis and requiring them when it's necessary. I can't imagine a better use of that requirement than when you're putting a large-scale facility in a UMA. Thanks.
Thank you. One more on the right side of the room there.
Thank you. Norman Wright with Adams County. I just want to echo that I further agree that we would really like to have alternative site analysis as a part of this stage of Rule 17. Also, to go back to the question earlier about, say, something of a unilateral standard of sorts. I mean, within the language right now, it says to mitigate to the greatest extent possible. Whether it's a mom and pop or a large operator, if we had some clearer understanding of what that means, the greatest extent possible within a UMA, particularly for these site-specific type of mitigations, I think it would help them in determining their investment. It would also help us in determining what is reasonable from our standpoint to achieve a standard with these best management practices. I mean, fire suppression on site seems possibly reasonable if, for example, the standard is to make sure that fire can be addressed within 30 seconds. But is there any intent to take from the somewhat I guess for us, the somewhat vague language here on what would be proper mitigation for a UMA, is there any intent to take that and develop a standard for UMAs that would be separate from what we see right now? Something that is a higher standard that makes these best management practices easier to pick and choose from and determine from an operator if they're going to invest, or determine from our standpoint what we're going to enforce. Any sense of UMAs getting stronger language later on?
I think the answer to the direct question is no, not at this time. I mean, quite honestly, a lot of thought went into how to address this, and for the reasons that I said at the outset, it does not make sense to us to try to list a set of practices, a menu that you could pick from, in large part because the technology evolves rapidly, and in significant part because every site is in fact different. So our practice has always been, and it is today outside of large facilities and urban mitigation areas, we have lots of engineers on staff, we have lots of environmental professionals on staff, and it's they who evaluate these sites and these locations and put on the conditions of approval. But that doesn't happen in a vacuum either. I guess it's important to say that. That happens with consultation, as this process contemplates more than ever with local governments. And that happens now as well. So our judgment was that we were better served by kind of putting operators on notice that there are these 5-ish topics that we expect them to come forward with. Here's how we're addressing these issues. If it doesn't look adequate to us or to the local government, and through the local government, the citizens, we'll talk about what else is available and what else might be more appropriate. I think I mean, where there were standards, I mean, your 30 seconds for fire, I have no idea if that's realistic. I have no idea if that exists anywhere else in the world. There are international fire standards. There are things that we could look at. We reference some of those standards in our rules elsewhere. If there were things like that that were applicable, I'm certainly willing to give that consideration. But in my experience thus far, there aren't a lot of those that we can pick from in a menu style. Okay, we're gonna keep going. We need to talk about duration. That's going to be a lively conversation, I think, as well. Let's take a break. We'll see you all back at 10:35.
Catch-all at the end that gives you some authority with best management practices.
Oh, yes. Yes. It's,
that's really big for me. I didn't see that.
No, that would be
Yes, so I did see that.
yes. Does this apply? What's your question?
Does that, well, when I read this, that was my question.
Yeah.
If that's clear, then any of my concerns go away.
Right. So that's what the very last sentence is intended to be. Is this is doesn't limit our discretion to impose conditions on Form 2 for any. So yeah, maybe we should have said outside of an urban mitigation area, but that's what it means.
When I drafted C,
Yeah.
I intended to give you authority outside,
Right.
as appropriate.
Right. And industry is totally flipped out.
Oh, I know it. I know it. Yeah, I mean, you wouldn't believe my telephone calls and a few angry discussions. That really reassures me.
Okay. Hello. How are you? Good. It's okay. Right. Right. Yeah. So you know about the Black Swan event? Yes. Sure, it can happen. Yeah, I appreciate you. I appreciate what you're saying. It could happen, but this building could fall down in an earthquake right now. Yeah, because I don't see the evidence to support that. I don't see the evidence to support that, and that's what we have rulemakings for. And we're not going to change the setback in this rulemaking. So I appreciate your comments, but we need to move past this subject for today.
What's the rule? I don't think so right now. This is how many feet?
It is what it is, 1,000 feet.
Always 1,000 feet.
It was changed in 2013. It was 150 feet and 300 feet, or 350 feet maybe. 350.
Oh my God! You guys need to increase.
Right.
Wherever I can.
Right. But we still allow them to be built. They can be built as close as 500 feet, as you know from Wadley Farms, because they're proposing it within 550 feet.
Oh.
Yeah, within a half mile is never going to happen. I mean, it's just not going to happen. I'm going to take the next one. I'm at.
Science ideas or
Yeah.
talking to some folks on the National Science Foundation.
Bob, of course, is playing it like he's like
trying to combine the recommendations from the task force on having working up some language around having a curated list
like everywhere proposed.
that could be updated as needed on an annual basis. In order to provide some transparency for community groups, local governments, industry, and it wouldn't necessarily be like
Right.
Right. But it provides a list of people saying this is what the scientists, regulators, I think a wide range of IOGCC, to have a curated list that could live at, I think you said that recommendation is CDPHE. So that's some of the things that we're hoping to put together.
I think that would be awesome. I mean, I think that'd be awesome, and I would go so far as to say if that comes into being and we want to, kind of vet it, but it could be referenced. We could even reference it in the rule. I mean, we could probably make it like an appendix.
Right.
There's precedent for doing something like that. But
I think
you can see how easy it is to get additional buy-in on these things.
No, I was just thinking that for the sake of transparency and for the sake of encouraging conversations between local government, industry, and community groups to have some sort of curated list where people are saying this is being vetted, these are what we think are the best management practices for air quality, water quality, soil, whatever that list of categories is.
Yeah. No, I think it would be very helpful.
Okay.
All right, quick. I have to go get a drink or I'll die.
Okay, so yesterday, I was focusing on here on the no limit.
Yes.
The number of wells or
Yes.
So if they want to put at 100, they can do it. You're not going to do it.
Well,
What would we do on balancing act between the no limits and the numbers if they go overboard?
I have to say that because there isn't a prescribed cap. I don't know what every situation is different. But the paste pad in Windsor that people have referred to, they proposed 28 wells, and I said no. Okay, but I can't tell you that I would always say no at 28. I might say no at 22.
And you guys say no based on the size of the pond or the land, how much land?
In that case, it had a little bit to do with the size. It was a 40-acre pad, not unlike Wadley Farms. But it really had more to do with the fact that there was so much undeveloped space around them. So they looking to the east, it was completely undeveloped. And it's like, why are you squeezing this in here when you have everything over here? And we'll look at Wadley Farms in that sort of same light. Wadley Farms is tougher, just so you know, because they own the surface. They're the surface owner and the mineral owner. It makes it harder.
you know, it's like they look at it, we own our homes and they have their assets. They have more assets on their balance sheet than what we have on ours. So it just kind of, you know, we continue. Okay.
What?
So can you tell me if you've ever said no?
Yes.
You have?
Not really. I get it. Yeah. Right. I don't know. This could be rule X. Okay. How many pages do you write on rule X? That's not as much as I need to know. I don't know why it's called hearing officer. It should be called hearing secretary. Hearing administrator. I like it. Yeah. Yeah, I do. It's Monday. That's the I mean, what that has done for public service is really actually huge. There's been enormous media and so forth. It's far longer than yeah, that's, we have a contract already with them nearby, and we were on site that morning, opining on what happens with the mine drains, and we started installing mine working, and we were offering EPA our advice on the inner mine working with clean water, but we won't take that's the whole area role. And is there anything and they all know each other, they all collaborating and so forth. But yeah, that morning when we started digging. Yeah. It's been quite a lot of things. There's a lot of hybrid stuff and also, but these things that I think that our program is taking out is opportunity. You know, because 1977 wasn't that long ago, and until then, you could do whatever the hell you want. Right, that's right. Exactly. And that's another way of celebrating so now we use no guessing. And we've been trying to get more all right. I'm just sneaking behind you there.
It doesn't feel that bad. As long as I'm not pushing it. Yeah. Oh, We're enjoying it. I just can't quite imagine it's a big run down the road. And then you run to the windy set or it's a good place to do that. It's pretty flat. Yeah, we get that a lot. It's kind of fun. We're here right? It's flat. It's kind of like for me on the northwest side of the drive. There's some folks. I was just talking to her. She's trying to she asked, after you're busy?
I tried to give you a call yesterday. That's when I meant to call back with the message, but.
If you want to look at UAB, which is probably the best way I believe that information is primarily through the website. Outside. You look at it. Anything that stands out.
All right, if everyone could find a seat, we'll get underway again. If you can't find a seat, we'll still get underway. Can the folks in the hallway, would you please try to make your way in so we can minimize the disturbance? It's a best management practice we're implementing. I cracked myself up. Okay, before we dive right back in, I did want to point out that Sarah Berwinski joined us quite a while ago, but she was also a member of the governor's task force, so I just wanted everybody to be aware of that. I think with that, we'll turn to the next part of the mitigation, the required mitigation measures. Actually, I did want to run through this. Wanted to run through this list of the BMPs, which just this list of 5 that we've had some conversation about. But to make sure everybody knows what we're talking about. The first one: fire, explosion, chemical and toxic emission hazards, including lightning strikes. Number 2, fluid leak detection, repair, reporting, and record keeping for all above and below ground on-site fluid handling, storage, and transportation equipment. Number 3, automated well control measures to prevent gas venting during emission control system failures or other upset conditions. Number 4, zero flaring or venting of gas upon completion of flowback, excepting upset or emergency conditions. Number 5, storage tank pressure and fluid management. And number 6, fracture proppant dust control. So as I indicated, I anticipate additional conversations about the exact language. I've been told that zero flaring is maybe not the best way to say that. So we'll work on the precise language, but the issues are those issues at this point. And then the required mitigation measures, I don't think we need to dwell on this one. The first one is that, as we've already said, all of our existing mitigation measures under 604C3 will apply to a location, a large facility in an urban mitigation area, including those that apply within 500 feet, whether or not the urban mitigation area is within 500 feet. And then this lengthy language pertains to the proposal to put a limit on the duration of drilling, completion, and stimulation. Fundamentally, I've already indicated the concept is that there should be an amount of time that the operator and the neighbors expect that 24/7 operations will be limited to. Again, we can't, I don't think, in my opinion, it's not practicable to put that number in the rule. Someone in the audience suggested a 90-day limitation. I don't think that's too far off of what we might reasonably expect neighbors to be prepared to put up with. But that said, it will vary, and it will vary by site, and it will vary by how the operator is going about their business. For example, depending on something that Mr. Busher mentioned, if you limit your fossil fuel fired engines, you might have a quieter facility. And if you have a quieter facility, it might be reasonable to expect that drilling would go on for a little bit longer. So the idea is that after we know exactly what the operator proposes to do and how, we would say that you need to complete your drilling and completion, and we use completion for those in the audience that might not know what we're talking about, we are talking about hydraulic fracturing and flowback operations. Any operation that goes 24/7 fundamentally is what we're after. We would put a limit on that. The rule proposes a one-time extension of that duration limit not to exceed 30 days for good faith, unexpected technical difficulties, or force majeure conditions. So again, we understand that things happen that can't be anticipated or predicted and maybe shouldn't be held against the operator. And in those circumstances, we wanted to make clear in the rule that our expectation was that yes, we would give you some additional time. The countervailing consideration is that we don't want that to be taken advantage of, and we don't want it to be granted too easily, and we don't want it to be granted repeatedly. So this was our first cut at that. By putting in the one-time extension of 30 days, I did not intend to say that under no circumstances would any other extension ever be given. I grappled with whether to put in the director will grant an automatic one-time extension, and obviously I came out on the side of not putting that word in, but that's kind of my intent, that provided that there is a legitimate technical difficulty or other unforeseen, truly unforeseen circumstance that arises, it would be pretty automatic to give another 30 days or some appropriate number to overcome that circumstance. If through some other variety and combination of circumstances, it simply became impracticable for an operator to do what they need to do, would we maybe give another extension? We might. My expectation would be that we would do so in consultation with the local government and through the local government, the community. So that's kind of how I envision it. The last sentence says the director may confer with local governments that receive notice of a large EMA facility in concerning the duration limit. Again, just for context, well, it's simple enough. We have learned from experience that if operators are drilling large well pads in close proximity to neighbors, the 24/7 operations could go on for months. Drilling times are getting faster. That's fabulous. We want to take that into account too. But 24/7 operations for 3 to 6 months it just pushes past a place that we can kind of in good faith say, hey, it's just temporary, it'll be okay. So the other thing this brings up is, let's say that legitimately an operator has determined that it will take 20 wells to drain the acreage that it has. And that's not an unrealistic number, just so you know. And let's say that realistically in a time frame that we agreed, if we ever agree, would be reasonable, they could drill 10 wells. Does that mean that they can only drill 10 wells and not develop their minerals? And the answer to that question is no, that's not what this means. What this means is that there would be some kind of downtime, some rest period, some quiet time, and then the operator would be back to drill those next 10 wells. And again, there's going to be a conversation there about, with the local government, maybe the preference would be that you do all 20. Get in, get out, go away. But maybe it's do 10 now and come back at some future date and drill the next 10. Okay, but we're not in a position to preclude the development of the minerals. We are in a position to try to minimize the impacts of those to the neighbors. Question in the front row. You know, because there are people on the phone and whatnot.
Hi, my name is Nicole Johnston. I'm from Aurora, Colorado. And I'm here today. I'm not an industry person. I'm a mom, and I've become a neighborhood advocate, I guess. And I have a question in terms of the mitigation. What happens if, let's say, even the 30-day extension is granted and it's still not met? When do you talk about the fines? And I don't know if this is the place for that, if it's somewhere else, who determines that? Because I know from some of the research I've done, some of the fines are a drop in the bucket to the oil and gas industry, and they'd rather pay the fines and maybe not even follow the rules because it's more of an advantage to keep doing that. So I just want to know where that might be into the rules, if that's even an appropriate time to ask this.
Sure, I'll answer it somewhat of a high level. But yeah, clearly if we impose this kind of a limit and they choose not to abide by it, they are in violation of their permit, and that would be a finable offense. I don't know when you did your research. The current rules, the current statute allows us to impose a fine of $15,000 per day per violation. So it's not a little. It's when the if they continue to violate it, it adds up fairly quickly. But I let me just finish, because I think you're not off base to anticipate that in the grand scheme of something, it might be their best option to pay $15,000 a day to keep drilling. And you certainly are alluding to that, and it would be a difficult question for us. But I think I will tell you that it is my belief that we would have the authority to say, you're going to stop. The COGCC body, that gentleman and his 8 colleagues. From the operator. Sorry. No, it's by statute. That's the General Assembly made that decision. No, from 1. It was $1,000, and the statute was 2014. So it was $1,000 per day per violation with a $10,000 cap for most violations. There's no longer a cap at all.
Hi, I'm back again, Pam Bond Simmons. I'd like to know who collects those fines, if there is a problem with enforcement of collection of the fines, and where does the money go to? Does it go to the general Colorado citizens? Does it go back to our Oil and Conservation Commission? Where does this fine go? And also, I'd like to know the percentage of times that you've actually collected the fines. Thank you.
Okay, I'll answer most of that, but I don't want to get bogged down in a conversation about our fine structure and our penalty structure. The fines go into the Colorado Oil and Gas Conservation and Environmental Response Fund. It goes into this agency's basic fund. There's some requirements about how we have to, for example, if we've used our attorney generals in the process of prosecuting that fine and getting that penalty, we have to give some money back to them, but more or less it goes into our fund. I'm sorry, I've forgotten the first part of your question. All the enforcement happens here. We impose the penalties. We collect the money. It goes into that fund. And you can see on our website, we publish all of the enforcement actions that occur and all of the fines collected from that. We do that on a quarterly basis, and we just published the most recent quarter. So if you have trouble getting it, call Julie. Raise your hand, Julie. Julie Murphy is our regulatory affairs manager. It's under her shop. But I can tell you that we've imposed a little over $2 million in fines to date this year, which is probably the highest ever. Okay, this is not the conversation I'm going to have today, okay? We have enforcement actions ongoing all the time. And I think there's a list of those too. I think there's a list on the webpage of every single active enforcement. And I'll also add that in addition to raising the penalty amount, we've increased the staff of our enforcement staff over the last couple of years. It was not very large, and it's now pretty healthy.
Jerry Nelson, Watley Farms, 550 feet away from a 20 well proposal. How much of a break do you think I would get between the first 10 wells and the following 10 wells? And I'm wondering if that would be enough for my 11 kids to get their sleep back.
Why don't you tell me what you think would be a reasonable break?
A reasonable break would be at least 1,000-foot offset to any kind of operation like this. And reasonable would be not in my neighborhood. Take a look. It's Franklin from 136 to 144th. Please drive by and take a look if that seems like a reasonable site.
Thank you. Can we pass the microphone, please? We'll get this, the gentleman. All right, who has the microphone? All right. Give it to Ms. Hall, please.
Kate Hall, Larimer County. I promise I'm not going into the penalty fee structure. I'm just curious, in cases where she had raised the issue, it may be more economically beneficial for an operator to just accept a fine and continue. Do you have the authority currently to maybe withhold the approval of that operator's other pending permits until they comply with their current violation? I'm just curious if that's something you could implement. I think that would appease quite a few communities. Thank you.
We do have authority to not continue to issue drilling permits to an operator under certain circumstances. Those circumstances generally involve repeat offenses. So hard for me to predict, in a given set of facts, whether, this gets to that level, but that is one of the tools in our toolbox.
Thank you. My name is Jim Lockhart. I'm with the Pikes Peak Sierra Club Group. I can see under this proposal how an operator could tell you how long his operation would be expected to take. And as you said before the break, you have the engineers and the experts to say whether that's a reasonable assessment. But I really don't see how the local community or the members of the community can engage effectively in this process. Do you have the land use planners who can advise you what's the impacts to the local community of a particular duration of drilling? How exactly do you expect the local governments, the local citizens to participate here? And if not, aren't you just going to have to take the operator's word, this is what I need and this is what you should give me?
I definitely think that there would be back and forth, and I would expect the operator to say that to me. We know we have data, good data, hard data, and we can share that data about how long it takes to drill these wells currently. So again, we look at the overall circumstance of how many wells. If it's, well, I've said 20, so I'll stick with 20. 10 1-mile laterals today, it's roughly, maybe I shouldn't guess. All right, hold on.
Well, I don't know, we need to spend a lot of time on this. I think the question I think you've answered is that it's the operator's need that can easily be shown, but the community impacts are going to be much more difficult for the people in the community to demonstrate. So what are you going to decide in the end? You'll have to take the operator's word, basically.
Well, I disagree with that. It's 12 days, by the way, in 2015, 12 days to drill and complete a 1-mile well. So 10 times 12 is 120 days. It's 4 months. That's not insignificant. So I would respond to you by saying I think that the community impacts are a little bit, they're more subjective. It's not, I can't exactly measure that. It's pretty clear that 1 day is more than many people would like. It seems clear to me that somewhere 3 to 4 month range, you're asking a lot of a community. The community wouldn't agree either. I mean, we could poll everybody and some people would say, hey, it's great, I don't care. Other people would say, oh my God. I mean, that's true now. It's true all the time with noise issues. So it's input from the operator, it's reasonable expectations that we would have, it's understanding this kind of data and the things I've already alluded to. Is it electric drilling? Is it electric fracking? Is it pipelined out? Is it truck trafficked? Is it remote fracking? Is it on-site fracking? All those things would be taken into account. So, Ms. Jost.
Thank you, Jamie Jost. Just one question. When you are talking about this proposed duration, have you taken into account the surface owner rights, mineral interest owner rights, the need for an operator to potentially be on a site for an extended period of time because of legal rights that they have, like lease extensions, lease rights, holding, things along those lines? And how does this not result in a drilling obligation? Thank you.
Ken, want to follow up on that? Okay. I will just solicit your further input on that point. Go ahead.
Could you go back a couple of slides, please, Matt? One more. Keep going back. There, nope. There you go. So I see Romanet little I3 basically saying you have to have equipment that shuts down your required safety pressure release system, which is designed to vent during upset conditions. And as you may recall, there's a rule when you are close to residences that tanks, atmospheric storage tanks, have a weak wall to ceiling seam so that they will split there when you have high pressure. So I'm basically reading Romanet 3 is saying we would rather have a bunch of tank roofs coming off the walls of the tank than have your pressure relief valve work the way it is designed. So did your engineering staff vet this? Go back 2 more slides. So this, no, to the duration slide.
Oh, forward, not back.
Forward, I'm sorry.
All right.
So I'm interested that you suggested you might have the ability to issue a cease and desist order for violation of an aesthetic rule. So good luck with that one.
Thank you. Ms. Robinson.
I just would like some clarification. You're talking about limits of drilling and completions for a 24/7 operation, but how about daytime occupations in a residential drilling situation? Do you consider any limitations to that?
I think I need to ask you to clarify what you mean by that, Leslie. I don't.
Meaning that if a company decides that they can do the drilling and occupation during the daytime, they could be there for years. And the impacts on the community would be a lot more than a 24/7 limitation of 90 days.
Right. So first, thank you for raising the question. Ideally, to me, that would sort of be the conversation. And I think this gentleman's point is well taken, that we're talking about doing this sort of on the back end when we have a much better idea of exactly what the operator proposes to do. And we would like community input into this process, but that is the trade-off. I mean, you've identified the trade-off. If we go 24/7, it's the 12 days per well that I talked about. If you do daytime operations only, and it's different for drilling than it is for fracturing, but it's still the same implication. Yes, they're going to be there much longer. And in many cases, operators would tell you that it's much less safe for them to shut down every night and start up again the next day. So they don't like it for safety reasons, for efficiency reasons, and so forth. So as a general rule, I mean, we have had conversations over the years about whether to impose nighttime, or shut down, and we never have, mostly for the reasons we've touched on. So that everybody would need to realize that that's what's implied. Much longer overall period of time of being on site drilling and fracking. Mr. Neslin. Oh, I'm sorry, I didn't see you over there.
I'm Donia Olivier, and I'm both a resident of Wadley Farms and have been on the HOA for 13 years. And in our community, we have had people move in, buy the homes, stay there for years. They either die or they move to another place to retire. Recently, we've had 5, 6 people move within the last year because of this operation coming in. And we live on acreage because we don't want to be near industry. We have zoning limits. And now we have this large-scale operation coming in. I think that moving this kind of operation into a neighborhood is unconscionable. So I ask that you reconsider the setback limits to protect these residents all over our state. These companies,
Ma'am, I'm
and
sorry, do you have a specific question or comment?
I have
about the
one more
duration?
comment, and
Okay.
then I will end. I know that Synergy has other places that they can drill that are not within residence areas. And so I suggest that they look and you require people to go to their outlying places and drill for that oil before they come and disturb neighborhoods. Thank you.
Thank you. Mr. Neslin, and then we're going to move on.
Thanks. Director Lepore, is there any regulatory precedent for this sort of duration limit, either with respect to oil and gas or other kind of construction that you've looked to or relied upon?
Not specifically that I could identify sitting here, Dave, except that, our APDs have a 2-year limit now, so there's a limit on those as we sit here. I don't think I'd have a hard time finding time limits on activities if I were to look. And it seems to me that you're suggesting maybe I should, so maybe we will. But yeah, I don't think that a permit, under any circumstances is an unlimited license to do what it is you need to get done. I've been wrong before.
Okay, thanks.
Thanks. Okay, we're gonna keep going. We've really got to get through this recommendation 17 and try to start on number 20. So in addition to, now we've gone through 2 out of 3 categories, I'm going to try to breeze through this last category, which is site-specific mitigation. In all of the outreach meetings, industry was very clear with me that we already have the authority to impose site-specific conditions. So I'm relying on that representation. We do have that authority and we intend to use it, and we would do that for, at a minimum, these kinds of issues in the large urban mitigation area facilities. Noise, perhaps things that wouldn't otherwise be required by our noise rule, we might ask an operator to do if they're doing a large urban mitigation area facility. Same with ground and surface water protection, visual impacts, subject to sort of the issues that have been raised about local governments, remote stimulation operations. Those are some that we've identified. Fundamentally, my thinking on this is we're simply putting on industry on notice that in these kinds of facilities, there would be some expectation that these kinds of issues would be addressed on a site-specific basis by conditions of approval. The next part is just a savings clause for us to say that just because we listed a bunch of things up there doesn't mean we can't also put other things on it. Similarly, it doesn't mean just because we listed these under a rule for urban mitigation area large facilities, we can't require the same things on other locations that are not inside the urban mitigation area. With that, oh, dang it, we were so close. Go ahead.
Okay, hopefully this is a small one. This is Tori Jarvis with Northwest COG in the town of Erie. And for the site-specific, especially given kind of some of the earlier conversations that there's certainly work that local governments have already done with operators oftentimes to address some of these issues. We wanted to suggest that at the very beginning of that C, I don't know if you could go back one slide, might help to look at that. It says, in addition to the requirements of other sections of the rule, we wanted to suggest also that you might consider adding "and any local government requirements imposed pursuant to land use approval or an operator agreement," just to kind of recognize that there's the potential for some additional burden on the operator, even as like a double regulation from the local government and from the COGCC, that it might kind of help to alleviate some of that.
Thanks. And so first of all, I really appreciate the specific suggestions. And then second, I just want to say it'll help us a lot if we can see that in writing in the not too distant future. Okay. So I just want to check in with the phone, folks. I understand there have been some issues, maybe other than the delay, so maybe you'll get back to me in a few minutes. But would you just let me know if you're still able to hear us okay?
This is Carl. I can hear you just fine.
Thank you, Carl.
Mark Riber from Erie. I can hear you fine.
Great, Mark. Thanks. Sounds like there's less of a delay now, too. All right. Any questions from anybody on the phone or any comments? Thanks. You're not on the phone.
None at this time.
All right. Stan, go ahead. Thank you.
Thank you, Director Lepore. Stan Dempsey, CPA. So where I've been confused about this recommendation or these draft rules is if you have, like with noise, for example, you have a standard, you have a rule, you apply it across the board, or the groundwater monitoring, particularly for different parts of the state. Would there be the standard apply and then another mitigation measure that would exceed that existing standard? I guess that's where we've had a lot of discussion, and I appreciate you saying that we've made some of these arguments to you, but I think it's the application of the BMPs on top of an existing standard that we're unclear about how that works.
Sure. Short answer is you got it right. Yes, that's the concept. So I'll use the noise one because number one, we are developing a new rule, so I don't really know what it's going to say. But let's pretend that it doesn't require an operator, generally speaking, to have 24-hour sound monitoring around the perimeter of their location. Okay, that for whatever reason in the course of the rulemaking for that particular rule, we felt that was not something that needed to be imposed on every single situation. Here in urban mitigation areas, for what I hope are fairly obvious circumstances, we might say, yes, as a condition of this permit at this location, that is required, that you will monitor the noise 24/7 at the perimeter. Absolutely no different than what we do right now today on permits all the time. We look at our standards, our standard rules, and we say, because of a site-specific circumstance, here's something different or greater than that is going to be required. So it's really not new in that sense. And yes, typically they go beyond. I'll go to the groundwater one. I don't know what I think. Wadley Farms, a lot of people are on wells. Is that right? Are you sure? Okay. Everyone is on water wells. So given that circumstance, even if they're in GWA, might we want to apply a different groundwater monitoring regimen than we have in our existing rules under 318AE4, I think it is? And the answer is yes, we might, based on those site-specific circumstances. And we would assert that we absolutely have that authority.
Just as a follow-up, and thank you for the answer. We've seen this increasingly where, maybe not in the context of the Oil and Gas Commission, but other regulatory contexts where there's two standards to be met. Would there be two groundwater standards to be met then? you'd have the 318 AE, right? The GWA, and then you'd have a site specific. Would you be fulfilling regulatory requirements, one through your permit, one on a general basis for two different approaches?
Well, yeah, I mean, I think I guess as a general proposition stand, and I don't want to be misconstrued. In general, if we have an existing rule on something like noise or groundwater monitoring, the additional ask or requirement would generally subsume the existing rule, I guess. I mean, maybe that's not true in the example I gave with noise. Yes, you would have to comply with our noise requirements, and you'd have to monitor sound all the time at that location. So you would have to do both. So it's an add-on. In the groundwater monitoring situation, my assumption is that we'd be asking you to do what 318 AE4 requires plus some, and in doing the plus, you would automatically be complying with 318 AE4. Okay, I hope that's clear. It wasn't that clear to me. Yes, ma'am.
Yes, I have one question.
Can you speak into the microphone and tell us who you are?
Linda, I live in Hunters Glen, and I haven't heard this asked. Are you allowing Class 2, and I know those apply to the oil and gas industry alone because there are several different classes. 2 is the second most dangerous, injection wells on UMA sites, because they also are even more associated with seismic activity and earthquakes as shown by the USGS.
I did talk about this a little bit yesterday. So
I'm sorry.
That's okay. First of all, Class 2 wells are permitted through the COGCC. That's a federal program, and the federal government has given the state of Colorado, COGCC, primacy over Class 2. Second, Class 2 are for disposal of what are called exploration and production waste. It's produced water is sort of the standard example. And they can also be used to inject water into the ground to enhance oil recovery. It's called secondary recovery. So that's what Class 2 wells are. Would we allow one in an urban mitigation area? What I said yesterday is that a Class 2 well does not have an associated property right with it. So there's no reasonable accommodation doctrine. The proponent of that well can't say, I have a legal right to get to my minerals underneath this surface.
Cannot say.
They cannot say that. So given that absence of a property right, there's more room for regulation of the location of those wells through other local government mechanisms. So I can't say that absolutely there's no at this point there's no ban or prohibition on a Class 2 well in an urban mitigation area.
Wow.
But it's a different circumstance than the oil and gas exploration and production wells.
Thank you.
All right, let's go to recommendation number 20. So recommendation number 20 in broad brushstrokes was intended to facilitate planning between operators and local governments. And the mechanisms to facilitate that planning were, number one, a requirement that oil and gas operators register with the local governments in which they do business. So currently, oil and gas operators register with the COGCC, and so we know the name of that operator, and we know their emergency contact information and all of those things. We issue them something called a Form 10, Form 1. Form 1. So the first part of recommendation 20 is to require operators to register with local governments. As usual, we will build into this a provision that the local governments can opt out of this process if they elect to. Once registered, at the request of the local government, the operator would be asked to provide 2 sets of information. The first set is an estimate based on the operator's current business plan of the number of wells the operator intends to drill in the next 5 years in that jurisdiction. That's because I can't read the other stuff. And the second set of information, that's the first set of information. I'll come back to that. The second set is a map showing the location within the local jurisdiction of an operator's existing well sites and related production facilities, sites for which the operator has approved or has submitted applications, permit drilling applications, and sites which the operator has identified for development on its current drilling schedule for which it has not yet submitted applications for commission permits. Okay, does everybody at least have a ground level grasp of registration? Two different sets of information. One set of information about where you have wells today, where you have permits to drill wells today, where you plan to drill wells but don't yet have permits. That's the first set of information. The second set of information is, in this jurisdiction, a good faith estimate of the number of wells you plan to drill in the next 5 years. That's the outline. So let's go back to some details. As drafted, this recommendation number 20 did not include counties. The drafter of this limited it to municipalities. And there were conversations at the task force about that, and it remained at municipalities, and it was voted on as municipalities, and it passed 21-0 as municipalities. As we went out into the community and held these outreach meetings, we heard pretty consistently, with one exception, that counties wanted to be included as well. We have not included counties in the proposed rule, and the reason is it's not in the recommendation. It's hard to recreate history. It's hard to unwind history. It's hard to say, what if, et cetera, et cetera, et cetera. Again, it was very clear that counties would like to be included in this information. It was very clear from the other side of the equation that the task force recommendation said municipalities for a reason. So we've left it at municipalities with this twist as what we hope is a fair middle ground. We have asked that operators do provide this information to municipalities and include in that the municipality's growth management area. So municipalities by statute can look out beyond their borders and say, here's where we're going to grow. Here's where we will annex. Here's where we might build our municipal softball complex. They have a formal process for doing that. And when we talk about local growth management areas in this context, we would expect that those local governments would have approved those growth management areas through a formal process, and that we're only talking about those formally approved growth management areas. We similarly would assume there would be a map readily available for the operators and for COGCC to look at, so that we would all know exactly the scope of the requirement. That too is not in the recommendation. But from our point of view as staff in putting this draft proposal forward, it is in the spirit of the advanced planning and collaboration and cooperation. I will just tell you, I feel fairly strongly about this in this way. We can make all the rules we want to, and if we can't get some planning around where suburban development happens in relation to the mineral owners and the mineral development, if we can't start to plan that, we'll be back here again sooner rather than later. And I said as much at the task force, and I'm saying it again now. there's shared responsibility here. There's shared responsibility among local governments who approve subdivisions without giving a thought to how the minerals are going to be developed or where. We can't keep doing that. So we are asking, again, in the spirit of that planning and foresight, that we extend beyond the narrow definition of municipality, not to counties, but to municipalities and their growth management areas. A second aspect of this that needs conversation is that, as written, with respect to the wells to be drilled in the next 5 years, a standard was put into the, a basis maybe is a better word, was put into the recommendation that said that that estimate of 5 years would be based on an analysis of the operator's proved undeveloped reserves as reported to the SEC. Okay, and my understanding of the reasoning for that was that that's a number, that's a calculation that the operators do now and have now, so it's available to them and they work with that, it's familiar to them. It would be more readily available to them. I understand that logic. The problem is that only publicly traded companies report to the SEC, and not only publicly traded companies operate in Colorado. So we have some significant operators who have assets in and near municipalities who are private companies. And if we adhere to that SEC concept, they certainly an interpretation could be made that they would be excluded from this requirement. Again, we don't feel that that comports with the spirit of the recommendation. And furthermore, there was virtually no discussion of that aspect of this recommendation during the task force. So based on that, we have proposed at least consideration of having this rule apply to both publicly traded companies and private companies. I just don't see a good reason to make this apply only to public companies. So I'll, with that, I'll go through a little bit, some more of the details of the actual rule. So the first part, 302C1, is our definition of what we mean for this subpart by local jurisdiction, and obviously you won't see county listed there. Someone has suggested to me that we inadvertently have excluded municipalities in some way who aren't home rule or statutory cities, towns, or territorial charter cities. So some of you local government types in the room, if you can help me with that, I'd appreciate it. That wasn't our intent. So somebody said to me that I'm going to make up a name, like maybe Hudson is a municipality, but it doesn't fit this definition. We didn't mean to exclude somebody like that. So if I'm missing something, please let me know. I don't think there's much controversy about the registration process. We've suggested that it start to happen on March 1. That's just kind of a month or 6 weeks after these rules are likely to be adopted. And so now we're on to the information requirements. And this is the 5-year number of wells planned to be drilled. So I've highlighted some language in green. Okay.
Jevin Rideau with Encana. Is there a way that the commission can somehow work with the local government designees to have some type of, if we know we're registered or how we're going to register, or if they want us to register, is that a possibility to look into?
Yeah, Jevin, it's a good question. We're going to try to work something up so that that information is readily available on our website. And the opt-out question, I think we need to figure that out too. But we will figure that out, hopefully by March 1st. Yeah. there was a suggestion during the task force that Mr. Wanstolen made, maybe it was after the task force, about doing it on the web and electronically and so forth, and we'll pursue that conversation as well. It certainly, it makes sense. Whether it's easy to implement is a different question. Okay, so 5 years, some language in green for us to consider. It's a good faith estimate. I just think, you know, we need to have some standard. We've got language later on that says that all of these estimates are subject to change. The bracketed language, including the jurisdiction's growth management area, I've already talked about. And then what we've said here is that a publicly traded company's well estimates may be based on reserves classified as proved undeveloped for SEC reporting purposes. We said it this way for the following reasons. One, to me, a clear reading of that language is that private companies also would be obligated to report. Second, that we are not telling private companies or public companies exactly what they must base their estimates on. We are giving them the option to base it on the proved undeveloped reserves, assuming that that is their preferred methodology, that it's something that's easy to them, available to them, et cetera. We did hear from many publicly traded companies during the outreach meetings that that's not so easy to do, that it happens at a large aggregated basis. So maybe you can tell me how many wells you plan to drill in North America, but not in Weld County. Weld County is going to opt out, so bad example. Boulder County. Okay, so it's not easy to disaggregate. So our thought is, okay, you don't have to do that. You can do that. As long as you can give me a good faith estimate, we're good to go. Okay, the next part, same inclusion of the growth management area. I think the rest of that language, except for the other part in green, tracks the recommendation language pretty closely. We put into this as well drilling and spacing orders. So there's been a reference earlier to drilling and spacing orders for those of you that don't know exactly what that is. Sort of in oversimplified terms, when an operator has an acreage position, they have leased minerals, or they own the minerals outright, they come to the commission and they identify an area that they want to develop, and that area includes their minerals. It may include other minerals, but we call that a spacing unit. And in the world today of horizontal drilling, a spacing unit is frequently 320 acres, frequently 640 acres. To give you context, 640 acres is a square mile. So 320 is half a square mile. So we see a lot of spacing units that are 320 or 640. So that is one of the first things an operator does when it's made a decision to go forward and start to drill those wells and develop those minerals. So we've included it. And the concept here is that it's an early indicator, earlier than the permits, more concrete in some ways than just, you know, I think I might go get a permit. If you've come to us and asked for a spacing unit, that's a pretty good indicator you've got some relatively near-term plans to drill. Not a guarantee by any means. Operators like to have an inventory of things to work with. But we felt that this would be a very useful planning tool for local governments. If a local government's paying attention and they see land get spaced by an operator, that would be a really good time to pick up the phone and say, hey, what are you thinking? What are you planning? What's your time frame? How many wells? What about surface location? So that's why we included that. Okay, last part of this, and then we can throw it open for questions. And heaven help us, we could maybe get done. Woo-hoo! The last part was our effort to put some sideboards around this and acknowledge the fact that these are forward-looking, planning things on behalf of the operator, that circumstances change, and that while these are intended to provide information and intended to start conversations and intended to facilitate planning, they're not intended to be relied upon in any sort of legal binding way, right? So all you have to do is think about the price of oil today compared to the price of oil a year ago to understand that if an operator gave you an estimate a year ago, it's probably different today. And we need that built into this so that, you know, there's some comfort that nobody's locking themselves in to a position or a commitment or an obligation. So this was our language, reasonable business judgment based on known information, and then the final sentence that those estimates could be subject to change at any time. All right, I'm going to stop talking. Look at all those hands go up. Love it. I actually saw the gentleman from, is it Adams County?
Yes, sir.
Go ahead.
Want to commend you on what is a very useful tool here, I think, and naturally, as representative for Adams County, we would love, of course, to have this option at our disposal too. The notion of having the growth management areas be applied to this rule number 20 is very, very good. Is there any chance, though, if counties can't be included, could at least the urbanized areas of a county be included? I mean, there's a definition that has to be created for what an urbanized area is, but there are portions of our county and many others that could certainly use this tool, will suffer these impacts. Those areas will not be in a growth management area within the next 4 decades, but certainly need this same type of resource. So if we could at least, if not the whole county, at least the urbanized portions that are going to require and need this, could they be considered along with the growth management areas?
So thank you. I appreciate the comments. I appreciate having another option to consider and you know, talk about. Just in general, very general terms, if I'm an operator right now, what I'm thinking is it really easy for me to identify those? And how do I identify those? Where do I look? Is there a map? All those things. So you can think about the answers to those questions. You know, any of these suggestions too, I mean, this just applies across the board. You can raise these, you know, we may or may not put something like that in the next draft of this, but it doesn't mean that you can't raise it in front of the commission. I hope somebody besides me is keeping track of who's next, but I think
I have raised the questions.
Are you gonna give me the God thing again?
Yes,
Because I can't deal with it.
No. This time is something
I stipulate. I can't control it.
Okay.
Go ahead.
Still about the drilling site in Wadley Farm. The site they proposed to drill the well belongs to Adams County, not city of Thornton.
Yes.
Okay. And so whatever they do there, they'll be not under this, because they belongs to Adams County. So I hope without too much difficulty, if you can also include that the county in this process, so that for our case, at least they have to follow this rule. The oil company has to follow these rules. Otherwise, there's no. We only follow this rule, right? But they can do anything they want because they belongs to the site they are doing is Adams County's.
Right. Thank you. We'll switch sides of the room next.
Okay.
Go ahead.
First, I really like the idea of the advanced planning. I think that is a fantastic part to put in. However, I am upset about not having counties also. As a resident in an unincorporated area, where do I go to get help? If I see in an advanced planning that they're going to be doing a well next to my home, where do I go if the counties are not included in this? And I really think that your commission needs to review the use of counties, because you keep saying local governments, local governments, local governments. I have no local government except my county commissioners. So I believe that you need to reconsider county.
Thanks. Let me just be clear. This is one proposed new rule. Counties do have local government designees. It's a program that's unique to the COGCC that I am about 99% sure Adams County participates in. So your county has designated a person as the liaison between the county and the COGCC. So you are represented. Adams County gets every permit to drill that is submitted to us within the county. And they have lots of rights and opportunities to engage with us in that permitting process. This particular rule of give me this information about wells 5 years out and so forth would not apply as it's written today, but I just wanted to clarify. So I'm going to come to this side of the room. Ken, you've had your hand up for a while. Jamie.
So just a couple of things, Matt. There was discussion of the distinction between a private company and a public company at the task force, and the obvious one is a public company is required by law to file these reports with the SEC. The private company is not. So most likely that's confidential business information on the part of the private company. So that was taken into consideration. And then I think you've made a good point that the information that's on the map is generally already made available to the county. The Form 2, Form 2A, existing facilities are on your GIS system. So maybe the only thing that's not provided today is the rare situation where an operator has an identified site for which he has not yet filed a permit, and that's going to be exceedingly rare. Final point is on the last slide, subject to change at any time. Be very helpful to include a key phrase from recommendation 20, which says at the sole discretion of the operator, and that is written directly into that recommendation.
Thanks, Ken. Certainly look back at the language of the recommendation. You know, I'll just be honest. I just struggle with the proprietary business information concept. We're asking for an estimate of numbers of wells, not where they are, none of that. And so we can agree to disagree. It reminds me, to be blunt, about the long, lengthy, and bruising battle over frac fluid disclosure. So just think about that. Jamie.
Okay, and on your, can you just flip back to the other slide? Just Ken stated most of my points, so this is going to be short. On the last part that says the site's operator has identified for development on its current drilling schedule. To the point of public and private companies, there could be instances where those locations are still subject to confidentiality under an SUA. And so you may have certain circumstances where the surface use agreement does not provide for that disclosure, let's say until the time a permit is filed. So how would you handle that?
Would you say the time that what is filed?
Yeah, and there may be certain instances that the confidentiality of the SUA is maintained until a certain point in time, and you're not able to comply with that third point.
I'm not going to try to answer that off the top of my head, Jamie. I'll just say that the language there, I believe, is word for word from the recommendation. And, if you've got that confidential or that contractual provision, maybe that's what you have to say to the local government is we now have something on our drilling schedule that we haven't applied for a permit for. When we apply for the permit, we'll tell you where it is. I don't know. Or maybe that gets back to the drilling and spacing unit too. Yeah. Oh my goodness me, oh me, oh my. So let's go to Miss Hall and then Miss Aldridge, and that's as far as I can see. But we'll keep going towards the back of the room in that row.
Thank you. This will be brief as well. In this Rule 20, I was just curious if there, or Recommendation 20 and the plans for advanced planning, I was wondering if there was any way, in addition to growth management areas, if we could consider enclaves that are county areas completely surrounded by municipalities, is that I'm not going to say a certain location. I'm just in general. I know there's several. So is there any way to consider that, since it may not be specified, but they would have a fairly decent ability to pull them into jurisdiction? And I think that oftentimes that municipality and that county need to be engaged.
Well, a couple of things. I think what I'm supposed to do here is say thank you and move on, but what the heck? Yeah. My handler is glowering at me. Again, my first question is that easy to identify? Can an operator go somewhere and look and say, oh, look, it's the enclave, we need to talk about that? My second thought is maybe some of those at least get captured by the idea of the growth management area. And I don't know, we've got a whole half of a room that probably knows whether Thornton's growth management area includes that unincorporated section of Adams County. So I don't know, appreciate the thoughts. Yeah, Mark, is that you? Okay. So appreciate that, and we'll keep going.
Thank you.
Susan Aldridge.
Thanks. Susan Aldridge with Anadarko. Matt, I recognize that this language came from the original recommendation that Jamie also referred to about the sites the operator has identified for development. But consistent with what you answered to Ken, that really what you're seeking from operators is more the number of sites. I wonder if we could clarify within here that it's more the number of locations that are anticipated as opposed to the sites, particularly given recommendation 17 and how that will unfold. I just think that indication of sites could be misleading as to what ultimately will get developed, given particularly 17 and how our engagement with those local governments could dictate other locations, if that makes sense.
Yeah, I appreciate that, Susan, and I'm willing to consider that. I don't know that there's something magical about the sites versus the number of wells, again, that you're really planning to drill this year that you haven't applied for a permit for. There is something else I want to say here in this whole context, and we asked this of local governments as we did our outreach meetings, and that is, what is stopping you from engaging in these conversations today? And I think the answer was nothing. So again, there's a little bit of an ask, I guess, from me that you have these conversations. You don't really need. One would like to think you don't really need this rule, or you shouldn't need this rule, and so have the conversations. And I know operators. Local governments tell me that, well, we ask the operator and they kind of blow us off. So we need a rule. All right, we're giving you a rule, but don't be constrained by that rule either. Go have the conversations. Who else is in the back there? Mr. Kramer? I don't know. Somebody else. I guess I could stand up and then I could see. All right.
Dan Kramer, City of Longmont. First of all, I think that including the bracketed language is a good idea. This is a planning exercise. It would be good for the local government to have that information rather than not have it. My question is about enforceability. Understood that the operator may need to change some of these estimates, but is there any other side to the equation where if the operator is really not seeming to conform to these estimates in reality, that there's some way to enforce this provision?
Well, clearly if we make a rule and an operator flouts the rule, we need to have a conversation. I think that we would approach this in terms of, was there a clear ask? Was there a clear follow-up? Is there a clear just intent to not comply? If we get to that spot, then we'll have the conversation with the operator that, this is a requirement under our rules, just like it's a requirement to file production reports or a requirement to file a completion report or something else. Really, the last place I want to be, again, regulating relationships between local governments and operators. And I have to remind you that there was a whole part of Section 20 that had requirements on the local government that they were going to take this information and incorporate it into their maps and their comprehensive plans and so forth and so on. So as envisioned, the recommendation placed burdens on both parties. It's just clearer than day that this agency has no authority to compel a local government to do any such thing. So that's not in the rules. But if we did, it would raise the same question. What if the local government didn't do the map? You know, I don't want to be there, Dan, so I understand the question, and that's the best answer I can give you. Ms. Harper?
Understood. Oh,
Sorry, do you have a follow-up?
Just a quick follow-up. But I would expect that if a local government were blindsided by an application, then its review of that application might be a little bit different than if it had a good knowledge leading up to the application that it was coming. That's something you were talking about yesterday, that there's nothing to stop an operator from applying to the local government much earlier than the minimum. I think that factors into this as well.
Sure. I think it's not directly on point, but I'll put it out there. I've never gotten quite to the bottom, and I'm a little embarrassed to say it, but I think we should be providing, this agency should be providing drilling and spacing orders to relevant local governments now, and I don't think we're doing that, but if we are, we're going to keep doing it, and if we aren't, I think we'll start doing it, again, for the very simple reason of giving those local governments an earlier notice that somebody probably has plans. All right, Ms. Harper? Dan, who's got the microphone? Can you pass the microphone back? I'm sorry. I'll get to you next, Ms. Sanchez.
Okay, so I live in unincorporated Weld County, as you know.
Yes.
And I have, I reached out to the LGD numerous times, and eventually, of course, because of my repetition and other issues, they completely stopped communicating with me about, and the group that is in Weld County that's also very concerned about the 2 petrochemical plants they want to bring into our neighborhood also were shut down. And then eventually, Encana did not relate to some of the neighbors who contacted them as well. So I want to go back to the question that somebody over here asked, where do we go next? So I've been coming here pleading my case over and over every month since December with numerous emails. As you know, I come to these hearings and nobody's helping us. And we live in unincorporated Weld County, which is a double blow. Where do we go? On that, I want to give you a second to talk about a minute to talk about that. But you keep repeating that the COGCC has no authority over local governments. Is that in the state constitution?
The authority of the COGCC is prescribed by statute. So there's the Oil and Gas Conservation Act. It's at 3460-101 if you want to look it up in Colorado Revised Statutes. That is the sum total of my authority, is right there in that statute. If it's not in the statute, this agency can't do it.
So you can't require every single LGD in this state to give you some kind of, to go through the process with Rule 17 that we were talking about yesterday. Why can't you require those LGDs to communicate, to interface with citizens, and follow these rules?
Just for the reasons I've already said, I can't require a local government to have an LGD. There's no requirement that any local government have an LGD. And you know, we encourage it, we meet with them, we offer to train them. There's a lot that we do.
An LGD that wants to relate, then what about that level?
Again, if I absolutely no control.
So I have no recourse except for a lawsuit or something like that. Is that what you're saying?
Well,
I mean, I don't know what you're saying. There's no recourse for people in Adams County and us.
Well, there's a ballot box.
Or change the statute somehow? Is that what is that what you mean by that? What about that statute where you guys get more power to influence the local governments?
I'll just tell you that.
No, I know a lot of people don't want that, but the people out floating in unincorporated areas that don't get the help they need, it's a problem for us. And there's a lot of us.
Thank you. Ms. Sanchez.
Kim Sanchez from Boulder County, and I'm actually coming at this not as an attorney or industry, but as a planner. So somebody that would actually use these tools for our utility and long-range planning. We do see this as a valuable planning tool, and we do think that counties should be incorporated. We would argue that counties contain areas where the land use patterns are indistinguishable from our nearby cities and towns. In fact, the unincorporated county lands are likely to see the heaviest concentrations of drillings. And so these are areas where the benefit of this advanced information could be the most beneficial to a planner to begin the conversations with operators about the best siting and mitigation, and where we could begin those conversations earlier to result in better outcomes. We are not in the practice in Boulder County of approving new subdivisions, so I don't think there's the same sort of fear, but also resultingly adding in anything about growth management areas is of no use for us. We would need the county to be included in this as a whole. We would love to begin having these conversations with operators on our own, but until something is in a rule, we don't see that actually coming to fruition.
Thank you. I appreciate that. I just have to tell you, and I don't understand the dynamics, but I know for a fact that Weld County meets with their operators monthly, and there is no rule that makes them do that, and I don't know what it is, but I just throw that out there, and I'm not offering that as a solution. I'm just telling you that seems to be a fact, and maybe you need to offer some homebrew beer or something. I don't know, but I appreciate your comments, and you certainly can carry them forward. Mr. Perlman.
Ben Perlman, Boulder County. Just to follow up on what Kim is saying, we do feel that it's absolutely vital that counties be included in this rule for all the reasons that she said, and it's not understandable to us why we wouldn't be. Again, most of the drilling is going to occur within counties. We would love to have that information. I think to add to that, it's important that the information actually be meaningful. And so I think there's an interest from industry to have it just be wells or numbers, but unincorporated counties like Weld or Boulder or Adams or Arapahoe or wherever there's going to be drilling are very large, and for us to know whether these are going to be drilled north, south, east, or west is useful information. And so the more that can be put on a map and the more that can be required to be given to us up front, the better. And numbers have some utility. Beyond that, not as much as what we really would want.
So again, I appreciate that. But again, I want to say, they give you the number of wells. You pick up the phone, say, I got your information. We'd like to have a conversation. And then you're having a conversation with them that maybe it's not on a map or maybe it's not written, which maybe eases their concerns about the disclosure of valuable competitive information. Just throwing that out there. All right, it is 2 minutes after 12. I'm being handed a question from Garfield County. With what frequency will operators be required to update their submitted plans? Fair question. I think the recommendation had language about material changes to the plans. I don't think we included that because I don't know what that means, and I suspect there'd be lots of disagreement about what that means. The simple answer is we elected not to put a time frame in there. If somebody has a great suggestion, I'm all ears. It seems to me that maybe annually is a place to start. And I think that's about all I'm going to say. So let me stand up so I can see the back rows. Well, let's okay. I'm gonna pick a random number, which is 3, and I'm gonna take 3 more questions, and then it's time for us to stop for today and reconvene tomorrow. So in the back, and then we're gonna go to Ms. Hall and then Ms. Jost.
On your last slide, when they can come back and change it, change the estimates. For example, if they submit the estimate and 3 years later they come back and completely change it, are you going to impose any limitations about the material changes? Or at that time on year number 3, when they materially change the plan, will you add another 5 years, or it's just going to be 2 years or 1 year for them to, do they have 1 year to implement it? Or will you add 4 more years if it's materially different to the original estimate?
I think that you are viewing this as something far more definitive than I am.
Yes.
For me, this is a planning tool. It's a place to start the conversation. It is not something that the local government should rely on and say, this is what's going to happen. They should look at it as a good faith estimate of current plans. And those plans could change in 3 weeks, or they might not change. So it's not nearly as formal and structured as you've just described it in my mind. Okay. I already can't remember. Ms. Hall, is that you next? Okay. All right. All right. We'll give Ms. Halls to you. We're going to come to Ms. Jost, and I do have one from Garfield County on the phone.
Tori Jarvis with Northwest COG, Town of Erie, and question for you, Director Laporte, is what type of, because certainly, especially Northwest COG area is very interested in including counties in this. We've heard from our members that this would be a very useful planning tool. Is there any sort of information that you're looking for from us that would be helpful to consider including counties? I don't want to repeat what other folks have said that we absolutely agree with, that subdivisions are, identical, and so impacts on citizens are very much the same. So if you have any suggestions, thank you.
Well, my first suggestion is to do it in writing. And I think there were some very clear statements about why it's important in your view. So it's okay with me if you repeat what Boulder County said, that's okay. But understand that this is a question that probably is going to go to the commission. I don't think at my level of the draft staff rules, you'll probably see counties get included before it gets to the commission. Since you're live and in person, can I go to Garfield County first? Thanks. Yeah, that's what I'm trying to read. No, I could just give me. Be patient. How about that? All right, well, I think I'm just going to read it out loud. Garfield County has had no problem learning about and actively engaging current as well as prospective operators in our area. A little effort by county staff jumpstarts advanced planning discussions. That came from Kirby Wynn, who is the LGD of Garfield County. I'll point out that Garfield County with Kirby Wynn is one of the few counties that has a sole dedicated LGD. So it sort of gets back to your question, Ms. Harper. A lot of LGDs wear 2 hats or 3 hats or 4 hats. And It's what they do when they're not doing their other job. And again, that's a decision that I have no control over. That's a county decision or a city decision. Those that have someone full-time, it makes a difference. Jamie.
Okay, I have one general comment and then just 3 logistics questions, if you could engage me in those. So I think the first comment is we've heard a lot of comments from the citizens and local governments today as part of 17 and 20. And I guess one thing to just really point out is that the COGCC process isn't the only process where citizens can be heard. There are local government processes, and many of those local governments engage operators for pre-application meetings prior to those permits. So I just point that out, that this is not the only process available and the only avenue. So then the logistics questions, and I'm sorry to dive into this, but I definitely wanted to get this out today, is do you know when the timing of the statement of basis and purpose would be put forth? For those of us that would be filing as party status and filing pre-hearing statements, it would be beneficial to have that prior to the pre-hearing statement so we could comment if necessary.
We will get it to you before the pre-hearing statements are due.
Great, thank you.
6 or 7 minutes at the very least.
That works, thank you. And then based upon all the comments today and then likely into tomorrow, does the state plan on submitting or publishing a new draft rule taking these comments into account before the pre-hearing statement date?
Yes, and you might not have been here at the very beginning. I don't remember. October 22nd at the latest for a revised draft.
Okay, great. And then when you stated earlier that you would welcome written submittals soon, obviously, I'm assuming that means prior to October 22nd for putting out the new draft, or were you submitting that with respect to the pre-hearing statement?
Yeah, I would love, and then as I've indicated yesterday, we have gotten a few things, and we will make those available as well. We'll link on our website, I think would be the easiest way. A handful of written submissions from a couple of counties, coalition of citizens, et cetera. But it's very helpful. I mean, it's very helpful to look at that language and say, where does it fit? What's good? What's bad?
Great, thank you. And then one last question, just overall with respect to 17 and 20, is when the COGCC staff was drafting these rules, was any analysis given to the potential impact on the mineral estate and mineral interest with respect to the limitations on surface development?
Well, I don't need to tell you, have a statutory directive to foster the responsible development of the oil and gas resources of the state, and we try not to lose sight of that ever. All right. Again, thank you all for your participation. We are going to convene tomorrow at 9. We've got the conforming changes to talk about. It's not the sexiest topic in the whole wide world, but what we'd really like to do then is see we've taken notes over the last couple of days. We'll try to winnow those down to some things that, clearly got a lot of attention and interest, and have a little bit of a conversation about some of those things tomorrow. Thanks.